they decided that, yes, this case is important. It has got public interest, maybe even world interest, national and world interest. But they said, however, they examine the merits of our application. They think that if they don't grant the stay, and in the appeal, if we were to win the appeal, the main appeal, then this entire proceeding that starts from tomorrow become nugatory, which means sia-sia. It'll be wasted. What will happen is there will be a retrial because of nullity. Okay, that's number one. And number two, they say there is absolutely no evidence of delay on our part. That is very important. I think you need to stress that, because they were alleging that we delay. The court found there is absolutely no evidence of delay. But as I told you, we came into this situation because of what happened last week. Only last week, when they withdrew the 418A. Because of that, we was forced to come to court. Okay? So we are not the one who delayed.
So
all right?
When will the trial begin? Do we know until the appeal is resolved?
Until the appeal is resolved.
Do we know when?
We do not know. And then after the appeal, one of the other party may want to take it up further. We don't know.
Are there any dates for the appeal yet? Maybe some case
No.
management dates?
No. Because the judge need to write judgment, records need to be compiled. But this judge, the High Court judge, you must give him credit, he's very fast. He writes judgment very fast. So you don't need to push him. He knows what he's doing.
Until the 3 appeals are completed.
No. This is one appeal on this one. The other appeal has already got a date. That is in March, what?
11. So the
March 8, there is already the 3 appeals.
So the trial will start after this appeal.
This particular appeal.
Okay.
Yeah. Because that other appeal, there is no stay. But I think practically, we may be having a situation where all the appeals will be merged in one go. I suspect.
But will you try to do your part to expedite the hearing of
We
this
always
appeal?
expedite. As you notice, they decide yesterday itself we file an appeal. We never waste a single minute. There are times when we file our application at night, because nowadays you can file at night because of e-filing. There's a beauty, see? So we never delay. If we are right, if we win the appeal, the matter has got to start all over again from the Sessions Court.
It's like as if bringing it all over.
All over again, because the process was wrong. You see, I almost stood up and say, you see, it is the rushing that caused all this problem. When you rush, you make a lot of mistakes. Now they still want to rush. This is what I thought. They should not. We should not take our own time, no, but take the measured period to do things, and to do things properly. When you rush, you make mistakes. We have to file petition of appeal. We got 10 days to file 10 days to file the petition. So that's why it cannot be rushed. To hear next week is no way.
Definitely out. March.
Out, yeah.
The trial date for March could still.
Possible, but I am inclined to think it may not be practical.
This is slightly delayed, but we will be able to commence hopefully within it's fixed for 2 months until end of March, so we'll be back within that period.
I think in March you'll be.
No, we should be able. We really think in terms of preparation of the record, it can easily be done in a week. There's nothing really. So thereafter is for the President of the Court of Appeal to fix a date. So we will write in view of the public importance of this case for early date to be fixed, and we are hopeful.
I mean, whose fault is that? I mean, for this hiccup.
It's not a question of fault. When you're conducting a criminal trial, the objections are taken, points of law are argued, and this is one of those points they took, whether we could withdraw a certificate. Usually some lawyers will just let it pass, because whichever route you come, you're still back at the High Court. We all decided to go to the same destination. They told us, no, you must go via A, and some said you can go straight. So there's nothing actually. You realize we have both agreed that this case should be heard in the High Court. It's whether by certificate or 417. So that's it.
And also there's no evidence of delaying tactic on the other side.
That's their opinion, but we have set out the reasons why. the judgment of the court has to be respected. It's in our view, the prosecution's view, that along the course of from the day this case was charged until now, we are of the opinion there has been delaying tactics.
Defense lawyer said that you guys were rushing things too much. That's why mistakes made.
Well, that's their view. Our view is we were doing our job.
Is the prosecution side ill-prepared that led to this ruling today?
No, we are ready to go on with the case tomorrow. So how can we be ill-prepared?
I mean,
It is they who are not prepared to go on with the case tomorrow.
What kind of impact it will have? Because you line up the witnesses as well.
It'll cause a little bit of inconvenience, but I think we'll be able to get it back on track very shortly, in a week or so.